Good morning. Today we are going to start with the offense of defamation, which is being defined in section 356. Okay, defamation is a tort also and a crime also. In the lectures which I have taken for law of tort, we have a video on defamation. It is a request that you better see the video and you will understand how defamation is a tort and what are the ingredients of a defamation which are required to be proved in a case, in a civil case, that is in a law of tort. Okay, now in tort, what they have done, they have divided the defamation in two parts, that is libel and slander. But in BNS, in criminal law, it is not distinguished like a libel and a slander, a written defamation and a oral defamation, a transitory defamation. It is being explained, defined together itself in 356. So we are not making distinction of defamation, types of defamation in criminal law. Okay, see 356 defamation, subsection 1. Whoever by words either spoken or intended to be read, means oral is also there and writing is also there. Whoever by words either spoken or intended to be read, or by signs or by visible representation, means that these three things are required here. A person, either he can speak, means oral, or intended to be read, that is written, or by signs or by visible representation, makes or publishes in any manner any imputation concerning any person intending to harm, or knowing or having reason to believe that such imputation will harm the reputation of such person, is said, except in the cases hereinafter accepted, to defame that person. There are 10 exceptions which are mentioned in section 356. Leaving those exceptions, if these ingredients, if these essentials are fulfilled, it will be called as defamation. We'll see again. Words spoken or read, or by signs or visible representation, makes or publishes in any manner any imputation concerning a person intending to harm, or knowing or reason having to believe that such imputation will harm the reputation of such person, means the mode either spoken, written or visible representation or sign is required. Second is publication of imputation is required, and that is going to affect his reputation of such person, will be called as defamation. Okay, these are the three essentials of defamation. Now explanation is being given. It may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living, and is intended to be hurtful to the feelings of the family or the other relatives, near relatives. Means if somebody affects the reputation of our ancestor, if he would have been living, it would amount to defamation. He is dead now, but he is our ancestor. Nobody can defame him or her. If they defame, that is going to affect our feelings, being their legal representative, the legal descendants. So it will amount to defamation. We can file a case against that concerned person who defames our ancestor. Okay. Explanation 2 states that it may amount to defamation to make an imputation concerning a company or an association or collection of person. Means defamation can take place of an artificial person also, a juridical person also. Okay. Explanation 3rd, an imputation in the form of an alternative or expressed ironically may also amount to defamation. Means if some person ironically is stating something, but his objective is very much clear, he wants to defame, then that also will amount to defamation. Means a statement which is being made alternative or expressed ironically can also amount to defamation if all the other ingredients are being fulfilled. No imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimation of others lowers the moral or intellectual character of that person, or lowers the character of that person in respect of his caste or his calling, or lowers his credit of that person, or causes it to be believed that the body of that person is in a loathsome state, or in a state generally considered as disgraceful. Therefore, when anybody states something which affects our character, which lowers our credit in the people with whom we live, maybe they are from our caste, or maybe they are our colleagues, maybe they are our relatives, or the people in general, the statement, the imputation is affecting the credit of ours, then that will amount to defamation. Okay, we'll see some illustration. A says Z is an honest man. He never stole B's watch, intending to cause it to be believed that Z did steal B's watch. Means the way A is telling that Z is an honest man, means the imputation is connected with the statement, how it is being made. A says A is an honest man. He never stole B's watch, intending to cause it to be believed that Z did steal B's watch. Then this will amount to defamation. If a person is making a clear statement that like Z is an honest man, if the same statement I say like that, Z, I know, is an honest man, means the statement I am making in such a way that you should consider that whatever I am telling, it is false. Okay, that also will amount to defamation. Z is asked, who stole B's watch? A points to Z, intending to cause it to be believed that Z stole B's watch. This is also defamation. Okay, means simple example of like Z is whether Z has stole the watch or not, that is been given in the illustration, but in different ways it is. Okay, now that also will amount to defamation. In what mode A says that Z has stole the watch, or Z is honest or not. Okay, means whatever statement, whatever imputation is going to affect the credit of the person will amount to defamation. We'll revise. It can be oral, it can be written, or it can be in signs or visible form. Okay, any representation made in a visible form. Second is it must be published. Third is that imputation is going to affect the reputation of such person. Then that will be called as defamation. Subsection 1 is stating the definition, it is providing with 4 explanations to explain to us what is defamation. Thereafter we are having 10 exceptions which states that it is not defamation. Okay, truth is a very good defense. So when a statement is made and which is very much true, which is made in good faith, then that is not defamation. Okay, this is exception 1. It is not defamation to impute anything which is true concerning any person, which is being made for the public good. Okay, means truth is a very good defense. Where the person is speaking truth, though case is being filed, he can prove it. If he proves, then this will not amount to defamation. Exception 2 says it is not defamation to express in good faith any opinion whatever respecting the conduct of a public servant in discharge of his duties. Means when we say certain thing in good faith relating to a public servant who is performing his duties, we are speaking something against him, but that is truth also, and that relates to his public duty, then that is not a defamation. We are having full right to do that. Okay, it is not defamation. Exception 3, it is not defamation to express in good faith any opinion whatever respecting the conduct of any person touching to any public question and respecting his character so far as the character appears in that conduct. This also will not amount to defamation. It is not defamation in A to express in good faith any opinion whatever respecting Z's conduct in petitioning government on public question. Means Z is filing a case against the government for public good. So that relates with a public character matter, and we are stating something relating to him. then that is not a defamation, because it comes in good faith, and that is an opinion relating to the person's conduct in public good, in public question. Okay. Now the fourth is, it is not defamation to publish substantially true report of the judicial proceeding. It is not a defamation. Exception 5. It is not defamation to express in good faith any opinion whatever respecting the merits of the case. The case can be either criminal or either civil. It is being decided. Means if we decide that there are certain loopholes in a case, the judgment, then that is not a defamation. We are having full right and we can make an appeal, and in an appeal we criticize the lower court's judgment. It is not a defamation. Okay. This is exception 5. Now exception 6. It is not defamation to express in good faith any opinion respecting the merits of any performance which its author has submitted to the judgment of the public. A person has written a book and he has published it. That has been kept for public opinion. We can criticize. If we don't like the book, you can criticize. You can have a review of that. Review and criticism of a matter which is put for the opinion of the public is not a defamation. An illustration has been given. A person who publishes a book submits that book to the judgment of the public. A person who makes a speech in a public submits that speech to the judgment of the public. Okay. A performance may be submitted to the judgment of the public expressly or by acts on the part of the author, which implies such submission to the judgment of the public. Okay. This is exception 6. Exception 7. It is not defamation in a person having over another any authority, either conferred by law or arising from any lawful contract, which has been made in good faith, any censor on the conduct of other matters to which such lawful authority relates. Means when a person, you can take an example of a judge. A judge in a good faith is stating something relating to the conduct of the witness or any officer of the court, then it is not a defamation, because the judge is the authority. He is having the powers to censor. He is having the powers to state certain things in good faith. It is not a defamation. It is not exception 8. It is not defamation to prefer in good faith an accusation against any person to any of those who have lawful authority over the person and respect to the subject matter of accusation. We'll take an example. If A in good faith accuses Z before a magistrate, if A in good faith complains of the conduct of Z, a servant, to Z's master, if A in good faith complains of the conduct of Z, a child, to the father, means the father is the authority, the magistrate is the authority, the master is the authority, and we complain it to the authority, we are making some statements in good faith, we are accusing that person, then this is not a defamation. Now exception 9 states, it is not defamation to make imputation on the character of another, provided that the imputation be made in good faith. See, in each and every exception, one ingredient is common, that is, whatever statement you are making, you have to make it in good faith. Made in good faith for the protection of the interest of the person making it, or for any other person, or for any public good. Means if a person makes a statement relating to a character in good faith for protection of his own interest or the protection of public good or for protection of any other person, it is also not a defamation. Okay, we'll take an example. A shopkeeper, says to B, who manages his business, sell nothing to Z unless he pays you ready money. Means don't give him credit, because for I have no opinion of his honesty. This is coming under the exception, because he is giving a warning. He is telling the shopkeeper to take a precaution that don't give credit, because in his opinion he feels that he may not pay the money. He may not be the honest person. So he is giving such a direction, or you can say such a suggestion to the shopkeeper to protect his interest. So this is not a defamation. This is exception 9. And now the last, that is exception 10. It is not defamation to convey a caution in good faith to one person against the another, provided that such caution is intended for the good of the person to whom it is conveyed, or to protect the interest of the person, or for public good. Means when as a caution it is being stated and it is being stated in good faith for a protection of the concerned person or for public good, then it is not a defamation. These are the 10 exceptions where the imputation does not become defamation. Okay, the first was truth. The second was statement made in good faith, any opinion whatever respecting the conduct of public servant. Third is respecting the conduct of any person touching the public question. Okay, the fourth was to publish substantially the true report of the judicial proceedings, court's proceeding. Fifth was when you state certain things on the merits of the case which is being decided. Sixth was in good faith when a statement is being made respecting the merits of the performance, performance of the author, means if somebody criticizes a book and all. Then seventh is it is not defamation having when a statement is being made by an authority who is having the powers to censor and in good faith. Eighth is it is not defamation to prefer in good faith an accusation against any person to the authority. We took an example of the father and the judge and all. Okay. Then ninth was when a statement is being made in good faith for the protection of the interest of the person making it, for any other person, or for public good. And exception 10 was it is not defamation to convey a caution in good faith to protect the interest. If the imputation, if the statement comes in the 10 exceptions, then that is not a defamation. So the opposite party, that is the accused, his advocate, can take these 10 defenses. They can say that the statement which he has made comes under this 10 exceptions. Then he will not be liable. Okay, this everything comes under subsection 1. Okay, now subsection 2 states whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years, or fine, or both, or community service. Okay. Subsection 3 is telling whoever prints or engraves any matter knowing or having good reason to believe that such matter is defamatory of any person shall be punished with imprisonment, simple imprisonment, extend to 2 years, or fine, or both. Means here the person is printing or engraving, and subsection 1 deals with whoever makes. Okay. Subsection 4, that is the last, whoever sells or offers for sale any printed or engraved substance containing defamatory matter knowing that it contains such matter shall be punished with simple imprisonment, extend to 2 years, or fine, or both. Means how the difference is, subsection 2 deals with subsection 1, that is the offense of defamation, whoever defames. Subsection 3 tells whoever prints or engraves, and subsection 4 is telling whoever sells or offers for sale. Means one who is doing defamation, he is liable. Second, the person is not making but he is printing or engraving, but he knows that it is defamatory. And the third is he is not either printing or making, but he is just selling it, and he knows that it contains the defamatory statement. These 3 people are liable. Okay, here we complete defamation. Bye bye. See you in the next video.